Finance and Policy and Elections Committee. Today being Tuesday, March 2nd, 2021, and we will convene the meeting of the committee. So welcome everybody, glad you can make it today. As you've probably noticed, we have a very full agenda and we are getting close. In a week from Friday, we will have the first policy deadline. So we are definitely going to have a lot of work. And I'd just like to mention as well that there will probably be some extended meeting times next week in order to accommodate all of the bills that we need to get through. To mention also, while we're at this, Senator Newman's two bills, 993 and 995, will be laid over. So I thought it'd be important for folks to know that ahead of time. Other than that, we are ready to start with our first bill today, and that is Senate File 691. And I'll move Senate File 691 and welcome Senator Housley. Glad you could be with us today.
Thank you.
If you would just introduce yourself, as you know, say your name for the audio record, and then you can go ahead and present your bill, Senator Housley.
Thank you, Madam Chair and members. I'm Senator Koran Housley. I have Senate File 691, but I have the A1 amendment, Madam Chair.
Thank you, Senator Housley. This being the first hearing on this bill, we'll consider this then the author's amendment, and I will move the amendment to Senate File 691. And I believe that, I'm not quite sure what the number is. The A1
A1.
Okay, I'll move Senate File 691, the A1 amendment. Senator Housley, to your amendment, it's a little bit substantial, so why don't you explain it even though it is an author's amendment?
Thank you, Madam Chair. It's a delete all amendment. It moves the regulation of the cosmetology to the Board of Health and eliminates the Board of Cosmetologist Examiners and leaves the Barber Board unchanged from its current regulatory arrangements. Do you want me to go into the whole thing then, Madam Chair?
No, I think that gives us just enough of a big picture idea. So on that author's amendment, I'll move that the A1 amendment to Senate File 691 would be adopted. And members, please take yourself off mute and be sure that you're on camera. All those in favor of the A1 amendment to Senate File 691, please say aye and raise your hand.
Aye.
Aye. Opposed? Motion prevails and is adopted. I heard something last minute. Okay. Sometimes it's getting off mute. We have a little delayed ayes coming in there on occasion. All right, members. So with that, Senator Housley, to your bill, Senate File 691 as amended. Senator Housley.
Thank you, Madam Chair. 691 as Senate File 691 as amended addresses the issue of board mismanagement and a systematic problem of regulatory capture in the cosmetology industry. Other states like Vermont and Colorado have successfully addressed these issues by putting licensing requirements within a state agency rather than an independent board that is made up of market participants. I often receive complaints from constituents about problems with this board. The legislative auditor is also looking into mismanagement issues. This transfer of authority is going to free up the cosmetologists and other in the beauty industry from the recurring issues they face trying to work under this board's jurisdiction. I have a testifier, Dr. Timmons, here with me that would like to speak to it also.
Thank you, Senator Housley, and welcome Dr. Timmons today to our committee. And for the audio record, if you remove yourself from mute, and also say your name for the audio record or title, etc., and then proceed with your testimony, Dr. Timmons.
Thank you, Chair Kiffmeyer and all distinguished committee members. My name is Edward Timmons, and I am a professor of economics and director of the Nee Center for the Study of Occupational Regulation at St. Francis University in Pennsylvania. I'm also a senior affiliated scholar with the Archbridge Institute. The main takeaways of my comments are the following. First, more than 100 million residents in the UK and Spain, and half of the member states of the European Union, have lived without barber and cosmetologist licensing for decades, and there's no evidence that consumers have suffered as a result. Second, the state of Alabama did not license barbers for 30 years, and there's no evidence of any direct harm to consumers. Finally, a recent research paper finds that consumers are much more interested in online ratings from peers than state-issued licenses when choosing service providers. My own research and the research of other scholars has shown that licensing restricts entry into professions and leads to higher prices for consumers. It is important to emphasize that occupational licensing is not the only way to regulate a service, but instead the most onerous way. The UK, Spain, and half of the members of the EU do not require barbers or cosmetologists to obtain a license to work. There is no evidence that the more than 100 million consumers in the UK and Spain have been harmed as a result. Barbers and cosmetologists in the UK can obtain certification if they choose to do so. It's completely voluntary. And barber and cosmetology schools continue to exist, and the market functions well. In the US, the state of Alabama did not license barbers from 1983 to 2013. Once again, there is no evidence of any harm to consumers over this 30-year period. My own research illustrates that it was only after years of intense lobbying from the Alabama Board of Cosmetology that licensing was reinstated in 2013. Consumers did not ask for this regulation. Many other important service providers, like barbers and cosmetologists, are not subject to licensing. Chefs and wait staff at restaurants and auto mechanics are not required to be licensed. Chefs and wait staff are regulated by random inspections, and mechanics can obtain voluntary certification. All service providers are regulated by market discipline. Poor quality providers will not be in business for long. I have never asked my barber to see a state-issued license. Instead, I ask my friends or visit the internet to learn about provider reputation and quality. A recent research paper more formally documents this behavior. In an online platform for home repair contracting services, it is shown that consumers are much more interested in online ratings of service providers than a state-issued license. Today, it is hard to justify why barbers and cosmetologists are licensed in Minnesota. The market's dramatically changed since many licensing laws were written. This proposed bill is an important first step, but it is time to more carefully reassess the costs of these regulations. The committee should consider the following oral amendment to line 2.11 of the bill, and I quote, "The commissioner shall evaluate if A, occupational licenses under this chapter are required to protect consumers, or B, a less restrictive regulation, such as municipal inspections, would address actual harm present in this state." Thank you very much for the opportunity to speak today.
Thank you very much, Dr. Timmons. I have a question for you, Dr. Timmons. So Dr. Timmons, who is most affected by this requirement and cost of licensing? I think it's really important to understand who is most affected by it and who benefits with this kind of a change. Dr. Timmons.
Yeah, so it will be both consumers who will have the benefit of having more choice in the marketplace and potentially having access to lower price services. And it will also be aspiring entrepreneurs who will have the option of entering the market without completing 1,500 hours of education to be a barber or 1,550 hours to be a cosmetologist. So both of those groups would be the most direct beneficiaries of reconsidering licensing.
Thank you, Dr. Timmons. I appreciate that. As one who have cut my family's hair, my sons and husband, although there's been a little less to cut over the years, so it's made it a little bit easier, but I'm glad I didn't have to have 15 hours of education. Yes, Senator Howe, I think you might benefit from that as well. Of course, our son just shaves his head, so we all find ways to manage this, and I appreciate that comment, but that's what I would say as well. The benefits are there, at least restrictive methods. Senator Housley, as to Dr. Timmons' idea, because you're going to a Health and Human Services Committee next, you might have another opportunity to do such an amendment, but I'd like to get your thoughts on it at this time, Senator Housley.
Madam Chair, yeah, I think Dr. Timmons, I think we should get that in writing, and we do have one more stop, so then we have more time for the public and for all of us to take a look at it and see how it would impact the industry and those folks who are implicated in it. So yes, Dr. Timmons and I think we'll get that language and we can talk about it going forward. I don't think I should amend it orally here today because this is the first I've heard of it too, but
Okay.
I like it.
Okay, thank you, Senator Housley. And I think members, this bill is on its way then to Health and Human Services. I don't see any other hands up at this time, so I will move Senate File 691 as amended to be recommended to pass and be referred to Health and Human Services Finance and Policy Committee. Senator Clausen, I see your hand just went up.
Thank you, Madam Chair. I just want to clarify with Senator Housley the bill, because I think the amendment that she gave changes the scope of the bill quite a bit. So I'd excuse my redundancy perhaps, but just I want to review it to make sure I understand. So the barber examiners would continue. That would not be part of your bill, correct?
Senator Housley.
Yes, that is correct, Senator Clausen.
Okay.
Senator Clausen.
And then the Department of Health would take over the Cosmetology Board functions. I assume that would include the Department of Health would regulate standards for sanitation, minimum training requirements, licensure, and so on.
Senator Housley.
Madam Chair and Senator Clausen, correct.
Okay.
Senator Clausen.
Thank you for that clarification. I appreciate your time. Thank you.
Yeah, thank you, Senator Clausen. I recognize that it was a significant change amendment, though it was posted. It's still very appropriate to make that clarification. Ms. James, you have your hand up for something.
Madam Chair and members, while the amendment was moved, I'm not sure that the members voted on it.
Okay, all right. Well, if in doubt, we will certainly take that action. I think not quite sure, but Ms. James, I trust that's what you watch for. You know those process very well. So members, let's take care of that right away first. So I'll withdraw my motion on Senate File 691 as amended to be recommended to pass. I will withdraw that. Instead, I will move the A1 amendment to Senate File 691. All those in favor, please say aye.
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 Okay, all those opposed? Motion prevails and is adopted. Seems like all right. And so with that, members, we have Senate File 691 as amended before the committee. Senator Carlson?
I had my hand up for quite a while here.
Yes. Senator Carlson, I did not see your hand up until same time I called on Senator Clausen. So I don't know if it was quite a while, because usually they pop right up on my screen to the top when you raise your hand. Okay. Senator Carlson.
Well, thank you. I have to say that there's something wrong here in that I was in the waiting room until 10:37. So something happened here where I was not allowed to be part of this group until 10:37. I was sitting here and waiting. I even had time to go get another cup of coffee while I was waiting. So I wasn't able to be part of the discussion nor the amendment. I do have to say that what I gathered when I did get in here is that there is some effort here to go after licenses of people that are licensed in their professions. And this is something that I've been aware of for quite some time, and that we do have to make sure that we're not overreaching here. I don't think you want an unlicensed doctor working on your physical body.
Senator Carlson, would you like because you're kind of describing things that are not accurate about this. So I think it would be better if maybe we just had Senator Housley, if you would just briefly speak to your amendment in particular, which is a delete all. So in speaking to your amended bill for the benefit of Senator Carlson, and my apologies, Senator Carlson. I don't know why, but as you know, with Zoom, the nice thing when you have in-person committee hearings, you just walk right into your committee room. Exactly. And takes care of that. Nobody stands at the door, right? So there are real benefits to being in person. But nonetheless, we are under this Zoom right now. And so Senator Carlson, Senator Housley will quickly describe the changes.
Just to be clear on what I need to be brought up to date on was the testifier was talking about the advantage of not having licensed people. And I guess I'd like to know what the author's position is on that and the description of why that's necessary.
Well, Senator Carlson, that was the testifier's personal comments. I think Senator Housley, you can go ahead and describe your bill as you've had it amended.
Thank you, Madam Chair and Senator Carlson. What the amendment does, it moves the regulation of cosmetology to the Board of Health and just eliminates the Board of Cosmetologist Examiners. And it leaves the Barber Board unchanged from its current regulatory arrangements. That's what the amendment does.
Senator Carlson.
And thank you, Madam Chair and Senator Housley. So that means the entire board is moved to the Department of Health. Is that correct?
Senator Housley, it's the duties. Is that correct, Senator Housley?
The regulatory duties. Correct.
Thank you, Madam Chair. And that includes the licensing as well.
Correct.
Senator Housley.
Madam Chair, Senator Carlson, correct.
Thank you, Madam Chair. Thank you, Senator Housley.
Thank you, Senator Carlson and Senator Housley. Okay. With that, I appreciate the fact that on this kind of a situation, Senator Carlson, we definitely needed to take that time to do that. So members, again, I will move Senate File 691 as amended, be recommended to pass, and be referred to the Health and Human Services Finance and Policy Committee. So members off mute, and please be ready on camera. All those in favor of Senate File 691 as amended, please say aye. Raise your hand.
Aye.
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 Opposed?
No.
Motion. Okay, motion prevails and is adopted.
Thank you, Madam Chair and members.
Thank you, Senator Housley. Okay, members, we are then moving on to Senate File 578, which is Senator Weber's bill. Senator Howe, would you do the motions for Senator Weber? You're on mute, Senator Howe.
So moved.
All right, Senator Weber, to your bill, Senate File 578. Welcome to the committee. Glad to have you here today. And Senator Weber, you are in front of this committee for a particular reason. We're going to try and stick to why this particular bill, not the policy underlying it, but the why is this bill before the committee? And if you would like, Ms. James can assist in that regard if you would like.
Thank you, Madam Chair. Senator Bill Weber from Senate District 22. Basically, the purpose for being in front of your committee deals with subdivision 2 of Senate File 578, and it deals with rulemaking. And the rulemaking provision here provides that the Commissioner of Revenue can amend Rule 8100 to conform to Section 1 of the bill, and may use a good cause exemption for amending the bill to incorporate specific changes as set forth in statutes when no interpretation of the law is required. And so with that, Madam Chair, I would, if Ms. James has additional information, that is fine. Also, Grania McKernan of Exile Energy is here as well if there's any discussion or questions for her.
Thank you, Senator Weber. Ms. James, did you have anything to add at this time?
Madam Chair and members, no, I have nothing more to add.
Thank you, Ms. James. Senator Weber, I noticed there's a good cause exemption. Could you explain the good cause exemption, what it is, and or if you'd like Ms. James to, she could help out on that.
Yes, if you would like to have Ms. James explain that, I'm fine with that.
Okay, Ms. James.
Madam Chair and members, the good cause exemption is an abbreviated process for rulemaking, not a full rulemaking. And it's employed in situations where the legislature has kind of fairly prescriptively told the agency what rules to adopt.
Thank you, Ms. James. I think that has to do with the fact that in line 1.11, it says the Commissioner of Revenue shall amend. Thank you very much, Ms. James. Senator Weber, we have a couple hands raised, so I'm going to go to, I don't know who was up first, but Senator Clausen.
Thank you, Madam Chair. This may be a question for our Xcel Energy person that's with us today. I'm just wondering if this action would result in any consumer savings.
Thank you, Senator Clausen. Senator Weber, do you want to respond to that or have Ms. McKiernan?
Well, first I'll take a shot at it, Madam Chair. Basically, the gist of the bill is dealing with the manner in which the Xcel Energy or any owner of wind and solar power facilities is being taxed. As we all know, they do not technically pay real estate tax on those improvements. Instead, for those type of things, they pay a production tax to the counties, and the improvements are considered tax exempt. However, the process by which that happens is by the depreciation of these particular assets. And what happens is that many times, due to technology changes in the industry, the system by which the Department of Revenue depreciates these pieces of equipment takes longer than what they're actually being used. And so by so doing, the process or the formula by which their exempt assets are depreciated away from their overall assets, they sometimes wind up basically they're being double taxed because they're paying on tax on equipment that they, quite frankly, haven't been able to fully depreciate within the process.
Thank you, Senator Weber. Senator Clausen, we're here because of rulemaking, but I felt there should be some latitude to have the explanation that you asked for.
Thank you, Madam Chair.
Thank you, Senator Clausen. Senator Carlson.
Yes, thank you, Madam Chair. And I've kind of not quite the same question, but it is related to, and from what I'm understanding is the rulemaking is actually in conflict with the statute, and we're trying to modify the statute so that the depreciation can be accelerated. And when that happens, is there a financial hit on this for the counties or for any entity where these taxes are actually paid? So what's the financial impact of this?
Senator Carlson, I'm going to call on Senator Weber, but I think if you follow the law and different rules, it's not a gift. It's following the law and the rules and the exemptions that are there for us to take advantage of. Senator Weber, for an answer to Senator Carlson's question.
Thank you, Madam Chair and Senator Carlson. It is my understanding that there is not, but I would advise us to turn to Ms. McKiernan to explain that further, Madam Chair.
Thank you, Senator Weber. Briefly, we go to Ms. McKiernan. This bill is going to go to the tax committee where all those issues will be dealt with in greater detail. But I have a little bit of latitude here. So Ms. McKiernan, there you are. Ms. McKiernan, if you want to go ahead and address that question.
Thanks, Madam Chair and committee members. My name is Grania McKiernan. I'm with Xcel Energy. I believe the question again, sorry, was about the cost impact. There is no cost impact to the counties because this doesn't affect the production tax. It only affects the personal property tax, to which we're supposed to be exempt. There would be in fiscal years 24 and 25 a very small revenue impact, but for us, it's not. It's a shift back to the taxpayers that right now we're picking up an additional tax that we're not supposed to be paying.
Thank you, Ms. McKiernan. Senator Carlson, that address your question?
Yes, I think so, but I guess I want to clarify, when you say that there is a small revenue effect, is that state revenue then? That's not.
Ms. McKiernan?
It would affect yes, it would be state revenue. I believe the 2-year fiscal impact is $340,000.
Thank you, Ms. McKiernan. Senator Carlson, thank you.
Thank
All right, so members, with having that understanding, Senator Carlson, you just happen to have your hand up yet, but I think we've addressed your questions. Thank you very much. Okay, members, with that, I will move Senate File 578 to be recommended to pass and be referred to the Tax Committee. All those in favor, please unmute and be ready to raise your hand. All those in favor say aye.
Aye.
Aye. Opposed? Motion prevails and is adopted. Senator Weber, thank you for being in our committee.
Thank you, Madam Chair and members.
All right, so members, we have the next bill on the agenda is Senator Newman. And members, just to let you know, as I announced before, both of Senator Newman's bills will be laid over for possible inclusion. So with that, Senate File 993, Senator Newman, 2-year bill.
Madam Chair, members, thank you for having me in to talk about these two bills. First of all, Senate File 993 deals with the Office of Administrative Hearings and would provide the administrative law judge that hears contested cases would give the administrative law judge final decision-making authority on all contested cases. Currently, an ALJ has final decision-making authority on some matters, but not all. Procedurally, what happens is one of our constituents, it could be a person, it could be a business, would have a disagreement with a state agency, and it could be any state agency. And the commissioner of a state agency issues an order from which our constituent would then appeal that order to the Office of Administrative Hearings. An administrative law judge is then appointed by the chief judge to hear that contested hearing. The hearing is, in effect, a trial in which evidence is presented either orally or from documents. The administrative law judge is responsible for employing the rules of evidence that are outlined in the Administrative Procedures Act. And after the hearing, the ALJ then makes a findings of fact, conclusions of law, and a recommendation to the commissioner of the agency that generated the contested case hearing. At that point, the commissioner of the agency has the authority to accept or overrule the administrative law judge. Procedurally, at that point, if an individual has had a case in which the commissioner has overruled the administrative law judge, the only thing remaining is after requesting reconsideration, assuming the commissioner does not change his or her position, the only thing that is remaining to the constituent then would be to appeal the case to the Minnesota Court of Appeals. And I will parenthetically tell you that I believe that when the contested case hearing finally hits the Minnesota Court of Appeals, it is the first time that a disinterested, neutral person with final decision-making authority gets to take a look at the case. Up to that point, the state agency, which is a party to the contested case hearing, and the commissioner are the individuals who are in charge of promoting the agency's position. So Senate File 993 changes that and gives that final decision-making authority to the ALJ. Now, parenthetically, I did get an email from an individual. This is somebody that I don't know, never met them, and they became aware of Senate File 993 and sent me an email outlining to me the fact that they had gone through this contested case hearing procedure, And the ALJ ruled in their favor, and the commissioner of the state agency then overruled the ALJ. And it's a perfect case to illustrate exactly what I'm talking about. And in this particular case, comes out of the state of Minnesota Office of Administrative Hearings, and it incorporates findings of fact, conclusions of law, and a recommendation by the ALJ. It is a document that is 20 pages long, involves 16 pages of specific findings of fact by the ALJ in this case. And after the ALJ has made the specific findings as to what occurred in this case, the administrative law judge made the following recommendation: to vacate the determination of the agency investigators, to rescind the order regarding the services involved in the in this case, and to vacate the order of the commissioner's revocation of the license. And the ALJ in this case went on to say, in this particular case, the ALJ determined that the county cherry-picked from the facts as presented in the case file, thus maintaining and sidestepping an inconvenient truth regarding eyewitness accounts and the medical evidence presented in the case. And as I said, this perfectly illustrates what I'm talking about, where an ALJ is presented with facts, with evidence. He determines what is admissible, what is not admissible. He is a neutral third party to this contested case and makes a decision. And all too often, the commissioner of a state agency will simply overrule the ALJ's recommendation. And what we have to keep in mind is that the commissioner is an interested person in the contested case hearing. The commissioner is not a disinterested person. And this is something that has been of concern to me ever since I got into the legislature, that we have got people who own businesses, people who are constituents who have an issue with a state agency, and they do not get a fair, impartial decision on their case until and unless they get to the Court of Appeals. And consequently, I have brought forward Senate File 993 to change that and put into the hands of the ALJ, who is the independent decision-making authority here, to make a final decision and take that decision-making authority away from the commissioners in a state agency. Thank you, Madam Chair.
Thank you very much, Senator Newman. By the way, we did just receive the fiscal note for your bill, Senator Newman, for Senate File 993. And to let you know, there is a zero cost to this. And specifically, the agency here, the OAH, states that the current complement of administrative law judge staff is sufficient to manage the change of issuing final determinations in contested case matters as required by Senate File 993. No additional funds would be needed for this work. I'm reading that into the record, Senator Newman.
Thank you, Madam Chair.
Okay, members, we are now open for questions, et cetera. So Senator Clausen, I see your hand up.
Thank you, Madam Chair. Just a question for Senator Newman. You mentioned, Senator, that all too frequently state agencies overrule a decision by the OAH. I'm just wondering, do you have any statistics on that or any data that would show how frequently this is occurring?
Senator Newman?
Madam Chair, Senator Clausen, the answer is no, I do not. I know that it happens, and I know that it happens having been involved with the Office of Administrative Hearings in the past and having dealt with some of the administrative law judges at that agency. But as to specific numbers, I do not have them, but I can assure you, Senator Clausen, it does happen. And oftentimes the commissioner will agree with an ALJ, but in those instances when the ALJ disagrees with the agency's position on a case and makes a recommendation to the commissioner that is counter to what the agency wants, in those agencies, it is not infrequent that the commissioner overrules the ALJ.
Thank you, Senator Newman. And Senator Clausen?
Yes, thank you, Madam Chair. Senator Newman, in your experience, is there a one particular agency or a couple agencies that seems to be more frequent in overruling the OAH decisions?
Senator Newman?
In my experience, Senator Clausen, I saw it happen frequently within the Department of Health and Human Services. Okay. But I will tell you that all of the state agencies are subject to Chapter 14, the Administrative Procedures Act.
Thank you, Senator Newman. Thank you, Senator Clausen.
Thank you.
By the way, Senator Newman, I as well have been in contact with constituents and others as well who have reported similar situations. So it is, I'm well aware of it. With that, Senator Clausen, I think your hand is still up yet. If you can put it down, it's helpful. Senator Carlson, you're next.
Thank you, Madam Chair. And it sounds like Senator Newman does not have the numbers, so I don't know if my question can be answered or not. And what I'm wondering is, again, I'll ask how frequently this does happen where the administrative law judge does overrule a decision. I'm sorry, where the state agencies overrule the decision from the administrative law judge, but also if the case that you mentioned, you said, I think, that the next step would be to go to the Court of Appeals, which I believe that would be 3 judges, and their decisions would be final unless it's appealed further. But I'm wondering, if you don't have the stats on how frequently this happens, do you happen to know how frequently the person does appeal, or the person or entity does appeal, and the ALJ is upheld, or the agency is upheld? Wondering how successful is the appeal process?
Senator Newman?
Senator Carlson, the frequency with which this occurs, I don't think is really the crux of the issue. The crux of the issue is whether or not the individual involved in a contested case hearing against the state agency, and you got to think about it in terms of, I'm up against City Hall. It is a daunting experience for people. And so I don't think the frequency that it happens is nearly as important as the fact that that constituent of ours is entitled to have an independent, unbiased fact finder. And that person is not the commissioner of a state agency. As to how often the Court of Appeals is implemented, I will tell you, not very many times. In my experience, people run out of patience, and certainly if you're going to go to the Court of Appeals, many people appear in a contested case hearing pro se. Not very many people are willing to take a case to the Court of Appeals pro se because they simply don't know how to do it. And they have already been, oftentimes in my experience, financially harmed by the actions of the state agency. I mean, this is their employment. This is what they do for a living. They don't have the money to hire an attorney to go to the Court of Appeals. So it doesn't happen very often. The times when you would see that happen is when, if we were dealing with a fairly successful business that has got some financial backing, then you will see it go to the Court of Appeals. As to how often does the Court of Appeals side with, or I should say uphold the decision of the ALJ? Years ago, I remember having a discussion with some administrative law judges, and we talked about the fact that 98% of the time a case is appealed, the Court of Appeals finds that the ALJ's decision was based on fact and law and upholds it. Now, that's sort of anecdotal, but it is a conversation that I, in fact, did have with ALJs in the past.
Thank you, Senator Newman. And Senator Newman, I think that's a really excellent point. It's a matter of justice on principle. And I think that's the greatest benefit of your bill here, Senator Newman, that is the case. The other thing is people have reported that rumors go around and people talk about it and how often they go through the work, they go to the effort appeal, and then the agency doesn't accept the ALJ's ruling. And so people just kind of give up a little bit. So I think it's important to keep those things in mind. Senator Pratt, you're next.
Thank you, Madam Chair and Senator Newman. So if I understand the crux of the bill, in a sense, this will streamline the process where the ALJ will make a decision, and then if there's a disagreement with the department, it goes directly to the Court of Appeals, kind of missing a stop. Is that a fair summary?
Senator Newman, to that question.
I'm not too sure. Procedurally, Senator Pratt, if there is a contested case hearing, that's like a trial. The ALJ makes a recommendation to the commissioner. The commissioner either accepts or overrules the ALJ. If the commissioner overrules the ALJ, disagrees with the ALJ, and then issues a commissioner's order contrary to the findings of the ALJ, at that point, your constituent has a right to file an appeal to the Minnesota Court of Appeals.
Thank you. Madam Chair, one other.
Thank you, Senator Newman and Senator Pratt.
Thank you, Madam Chair. And I scanned sections 527B that you referenced. Is there a timeline then for the commissioner to file a contested case, or I'm sorry, in a file to the Court of Appeals for arbitration?
Senator Pratt, I don't know if that's quite what's happening here. Senator Newman, if you could clarify that.
Yeah, the procedure here, Senator Pratt, is followed under Chapter 14, the Administrative Procedures Act. I can't remember, Ms. James may know for sure, but there would be a time limit for an appeal. I'm going to say it's 20 to 60 days. I don't know, like 60 days after the final determination is when the individual would have had to have filed the notice of appeal. I'm giving an estimate as to the,
yes, thank you,
date, but there would be a deadline.
There would be a deadline, Senator Newman, but also I think what Senator Pratt was seeing is that instead of that time delay of going back to wait for the recommendation to be accepted or rejected by the agency from the ALJ, instead this decision would be final by the ALJ. If the agency didn't agree with it, the agency could take it to the appeals court, or if the other party didn't agree with it, they could go to the appeals court. So the big thing, it saves time and work from the agencies of going back to them and all of that, and it delays justice for those who are going through this process.
Yeah, Madam Chair. Yeah, and
Senator
I
Newman.
apologize, Senator Pratt. I misunderstood the question. What the chair has just outlined is exactly what I would anticipate would happen.
Thank you, Senator Newman. Not being an attorney, that's high praise indeed from you as a very good practicing attorney. So thank you. Members, with that, I see no other hands at this time. And so we'll go to the testifier here, and we have Mr. Devereaux. And Mr. Devereaux, usually I would take the testifier first, and then we'd have this discussion. But I assure you, your testimony is still very welcome and appreciated. So, Mr. Devereaux, if you'd like to proceed and say your name and your title or group you're representing for the record. Mr. Devereaux, you're muted. Okay. We can't help you, Mr. Devereaux, from our side. It is something on your computer. If you float the cursor over the bottom of your screen, the mute will show up on the far left side. You just need to click it so the red line goes away. There you go, Mr. Devereaux. I still can't hear you. Check if your computer microphone is on. On the top left corner, there's usually a little button. You might say F1, F2, F3 on my laptop. Big thing is to get your computer microphone on. I wish we had gone to you first, Mr. Devereaux. We could help you a little bit more. Mr. Devereaux, we're still not hearing. If you try and speak a little bit, then we, even a 1, 2, 3, then we'll know. Nope. I can read your lips, but not hear your voice. Well, you took the time to be here today. Could you, if you would, how can we do this? All right, Mr. Devereaux, we really apologize for this. I see a hand from Ben Johnson. Mr. Johnson, do you have assistance here for Mr. Devereaux?
Chair Kishmeyer, members of the committee, I apologize. I will politely, Ben Johnson, Legislative Director for the Minnesota Department of Veterans Affairs. I can provide some of the remarks that I think Dennis was going to cover, though he is the subject matter expert as the state's Veterans Preference Officer. So I'll apologize if we're not able to fully answer any questions, but just wanted to note a couple of items, if I may, ma'am.
Just a moment, Mr. Johnson. Mr. Devereaux, we're still not hearing from you, and we're going to proceed to Mr. Johnson. And if you do get clear, then we'll come back to you for a brief time. Okay, with that, Mr. Johnson, go ahead. If you want to put your hand down while you do, then thank you.
Thank you, Chair and members. My name's, again, Ben Johnson. I'm the Legislative Director for the Minnesota Department of Veterans Affairs. We just wanted to alert the Senate to what may be unintended consequences with regards to changing this and its impact on veterans' preference, statute section 197.481. So the comments that we had provided would be that state agencies are expected to be subject matter experts in their respective areas. This has been a major reason for their establishment. The commissioner of the Minnesota Department of Veterans Affairs embodies the expertise of the agency and understands the particular challenges and difficulties that veterans experience when transitioning from military to civilian life. This is especially true regarding employment issues. While an ALJ is fully capable of ascertaining the facts and determining the applicable law, the commissioner provides a buffering of that in light of veterans' experiences of being and working, in light of the commissioner's experiences of being and working with veterans. While commissioners have very rarely reversed ALJ recommendations, in those cases where it was reversed, it was due to a deeper understanding of a veteran's situation. We would oppose legislation that would make the ALJ's report the final decision and cut out the Minnesota Department of Veterans Affairs commissioner from the process. Thank you. And again, I apologize for the technical difficulties.
I understand, Mr. Johnson. I'm glad you were on so you could address the issue. And we, Mr. Devereaux, we still do not have any audio from you, but I want to let you know that you can submit written testimony to this committee and Mr. Bjorn will help you. And also we will be able to distribute it to the rest of the committee. Senator Newman, do you want to respond to Mr. Johnson at this time?
I do. Thank you, Madam Chair.
Senator Newman.
Mr. Johnson's comment that the administrative law judge is fully capable of ascertaining the facts and determining the applicable law is absolutely correct. What is missing here is the fact that ALJs do not have to be subject matter experts. Every state agency that I have ever bumped into on this issue says the same thing, that the commissioner knows more about the subject matter area than the ALJ, therefore they should be the ones that make the final decision. Missing entirely the point that the commissioner is an interested party in the outcome of the action. And there is a question of due process when you get to that point. By comparison, in district court, state district court, on criminal actions, a district court judge is expected to handle everything from a misdemeanor to a murder one. That very same district court judge is expected to hear matters from conciliation court to the most complex civil litigation that comes before the court. And that is a system that has been put in about 30 years ago or 40 years ago, where we no longer had judges that were expert in a particular area. For instance, we no longer have a probate court judge. We don't have criminal judges. We have district court judges that handle everything. And what happened is the rules of evidence changed, and they are now the same in the administrative hearings, that expert witnesses can come in and testify to a judge. And the difference between an expert witness and a lay witness is that the expert witness can give the judge an opinion as to whatever they happen to be talking about. And the ALJ then is in a position, after listening to the expert, that could be the subject matter expert in the form of the commissioner. The ALJ weighs that evidence, applies the laws of evidence that are outlined in the Administrative Procedure Act, and then makes a decision. So my point is, the argument that all agencies make, the Veterans Administration no different, every one of them makes the same argument, that you have to be a subject matter expert in order to come to a full and honest and impartial decision. That simply is not true.
Thank you very much, Senator Newman. Mr. Johnson, you wanted to reply to that?
Yes, Chair Kiffmeyer, Senator Newman, I certainly appreciate that perspective. I just wanted to note for the record that the MDVA is a disinterested party insofar as it comes to the cases that are brought before the commissioner as a veterans preference case. I would like to note that our goal is to serve veterans and the communities that are under the auspices of the veterans preference statute. Our goal is to administer it as the statute is intended, and this changes it in a way that we simply cannot support. Thank you.
Thank you, Mr. Johnson. Senator Newman, did you want to comment to that further?
The only comment I would make is I agree with Mr. Johnson in terms of the purpose and the role, and I agree with him that we should be supporting our veterans, but that does not change my opinion in terms of the impartiality of an ALJ to make a final decision in these cases.
Thank you, Senator Newman. Members, with that, we're going to proceed to lay this bill over. Senate File 993 is hereby laid over for possible inclusion in the state government omnibus bill. And with that, Senator Newman, we're going to go ahead and also address Senate File 995. And again, just because it's an audio, Senator Carlson, I see your hand up. We've had a robust discussion, Senator Carlson, at this time.
Well, yes, but I would like to also just say that I appreciate Senator Newman's vigor in trying to make things go faster. But sometimes there are unintended consequences, and we have to look back and say that what has been set up has been a process that was set up by a panel just like what we have right now, and we do have to look at what the unintended consequences may be. And also respect the fact that it was done in the past for a certain purpose. And I think Mr. Johnson actually did a very good job of describing some of the unintended consequences. And I think our veterans need to be guided by the department and the agency and the rulemaking to give them the advantage. And this is an issue where the veterans have the advantage, and the Veterans Administration is I mean, they're not an interested party in the conflict, but they are an interested party in making sure the veterans get treated as the law and the rules have described. So thank you very much, Senator Newman.
Thank you, Senator Carlson. I will mention, though, that also what Mr. Johnson did was describe how the Veterans Administration is a party to the case. Very, very different. They do have expert testimony, but they are also a party. And as you said, to give them an advantage. I don't know, when you have parties in a case, contested case, that one should have an advantage over the other. You want to have a fair hearing. So with that, Senator Newman, Senate File 995. And so for the purpose of the audio record, Senator Newman, if you just repeat again your name and the bill number and stuff, and go ahead into testimony so we keep it clear.
Thank you, Madam Chair. My name is Scott Newman. I'm a state senator from Senate District 18 and Senate File 995. I am the chief author of that bill. In order to explain the bill, I got to give you just a little brief history on it. Back in 2011 or 12, I'm not certain of the year. There was on the ballot a marriage amendment and a voter ID amendment. And at that time, the Secretary of State in Minnesota was a man by the name of Mark Ritchie. And Mr. Ritchie, Secretary Ritchie, and myself ultimately got into somewhat of a heated discussion over the fact that he was using state assets to travel to different areas of the state to speak in opposition to, in particular, the voter ID amendment, of which I was the chief author. From that discussion with the Secretary of State, I began looking into what are the rules that govern elected officials and the Secretary of State from being able to use state assets or, having taxpayer dollars take them to where they can speak to groups regarding a particular ballot initiative or legislation. And it turned out that the laws in Minnesota were somewhat unclear as to what an elected official or the Secretary of State's office could or could not do. And I based that statement on the fact that in 2014, then Secretary of the Auditor, the state auditor, came out with a report, in effect, trying to give some guidance to locally elected officials, in particular regarding promoting or opposing school bond issues by a particular school district or elected officials of a school district. I then talked to Senate counsel about what prohibitions were in place in law regarding the prohibition of using taxpayer money to oppose or promote legislation or a ballot initiative. And there again, the law seemed to be pretty clear, or unclear, I should say. And in an email to me, Senate counsel says, bottom line, some activities relating to advocating for or against a ballot question may already be prohibited, but existing law may not reach the Secretary of State or all public officials. This bill explicitly and comprehensively prohibits certain types of activities relating to ballot questions for both the Secretary of State and from public officials. So I brought this bill forward because I guess I'm of the opinion that constitutional officers, public officials, elected public officials, other than legislators, of course, have an obligation and a responsibility to provide us legislators with information, with opinions, with recommendations, but I don't think that they ought to use their office as a bully pulpit to oppose or support a particular ballot initiative. I think that goes outside of the purview of their office, and to use the inherent prestige of a particular office, such as the Secretary of State, to either oppose or promote a ballot initiative seems to me to go beyond what their statutory responsibilities are. So I have drafted the bill in an effort to more clearly state what the Secretary of State can do when it comes to ballot initiatives and what other public elected officials can do when faced with the similar situation. And that really, Madam Chair, is the gist of the bill. It simply says that they can't use any public funds to promote or defeat a ballot question or use the inherent prestige of their office to do so. And I think it is good law that would give guidance to publicly elected officials and the Secretary of State as to what they can and cannot do when confronted with these ballot initiatives. School boards, for instance, are confronted with these ballot initiatives frequently. And according to the state auditor in 2014, the guidance and the laws in the state of Minnesota were not clear. Thank you, Madam Chair.
Thank you, Senator Newman, for a thorough explanation. Appreciate it very much. Okay, members, in regards to that, we'll be laying this bill. Oh, I see Senator Clausen has your hand up. Senator Clausen.
Thank you, Madam Chair. And Senator Newman, you brought up local school board referendums and bonds. And I know that the school board members have an obligation to inform the constituents of their district of referendums, of bonds, what the impact might be to the local tax base, what the funds would be used for, and so on. My concern is that someone could construe that to be advocating for. You see what I mean? There's kind of a fine line there because they have to inform the public. That can be interpreted that they're supporting. And I think there's a fine line that can be crossed there, and concerned about how that's going to be interpreted.
Thank you, Senator Clausen. Senator Newman.
Just be a concern I have. Senator Clausen, you are correct that school boards do have an obligation to provide information to voters regarding a particular ballot initiative. This bill says specifically that they can't promote or use public resources for the purpose of promoting or defeating the ballot question. That's quite different, I think.
Thank you, Senator Newman. Senator Carlson.
Thank you, Madam Chair. Senator Newman, you mentioned constitutional officers without delineating which ones you mean. Do you mean the governor as well cannot promote his own budget, promote his own initiatives?
Senator Newman, I think that might be different than a ballot question, but Senator Newman.
I was specifically referring to the Secretary of State's office, because that is the constitutional officer that would be involved in ballot questions.
Thank you, Senator Newman. Thank you, Senator
Chair and Senator Newman. So is that delineated in the bill?
Senator Newman.
Section 1, Senator Carlson, specifically refers to the Secretary of State.
Thank you, Senator Newman. Thank you, Senator Carlson.
Chair and Senator Newman.
Senator Carlson, you have another question or a comment?
I do, yes. Does that include, for instance, what we're discussing right now. If an agency and if the Secretary of State opposes something, can they testify against it in a hearing like this? I mean, this is using public facilities, and also it is many times, well, first of all, it can be viewed by anybody, and it's also put into the archives. So are you saying that this kind of testifying for or against an initiative is also included in that?
Senator Newman.
Insofar as the Secretary of State's office is concerned, in my opinion, yes. I do not believe the Secretary of State's office should use its position to be a proponent or an opponent of a particular ballot initiative. It's up to the legislature to pass legislation. It's up to the Secretary of State to carry out election laws.
Thank you, Senator Newman. Senator Fateh.
Oh, thank you, Madam Chair, and thank you, Senator Newman. As you know, ballot questions are not subject to the same campaign finance laws as candidate races. Corporations are allowed to weigh in financially without the same.
Senator Fateh, to the bill, please, Senator Fateh.
So, okay, I'm gonna get to that point. So we all can understand why we should not be using our public employee resources to support candidates, but why is an elected representative weighing in on an issue area under his or her purview, such as the Secretary of State weighing in on an election policy? Why is that more of a threat to the legitimacy of a ballot question race than a for-profit corporation spending millions of dollars in that same race?
Senator Newman.
Best I can say, Madam Chair and Senator Fateh, is that this bill zeroes in on elected officials. It is not intended to address what corporations can and cannot do when it comes to campaign finances.
Thank you, Senator Newman. Thank you, Senator Fateh. Well, with that, members, we will lay Senate File 995 over for possible inclusion. Thank you very much, Senator Newman, for being with us today.
Madam Chair, thank you. Members, thank you very much.
Thank you. With that, members, will proceed to Senate File 1019. And Senator Koran, as a member of the committee, you can make your motions.
Thank you, Madam Chair. I'd like to move Senate File 1019.
And to your bill, Senator Koran.
And Madam Chair, we also have an amendment as well.
All right.
So if we can move the A2 amendment to Senate File 1019.
Okay, Senate File 1019, A2 amendment. You can move your amendment, Senator Koran.
Madam Chair, I'd like to move the A2 amendment to Senate File 1019.
Okay, this being an author's amendment, it looks mostly technical, I would say, Senator Koran. Would that be correct? Would you like Ms. Daniel to go over it at all?
Madam Chair, we could have
or Ms. James, I'm sorry.
We could have Ms. James go over it as well. If we
Okay,
could.
let's put the, let's go ahead and have Ms. James just quickly go over the amendment.
Madam Chair and members, in the bill on its face, there's a section completely repealed dealing with an account and also duties for the legislative auditor with respect to driver and vehicle services data. The amendment leaves in place the account and then also now appropriates the money to the legislative auditor in statute, but continues to eliminate the duties with respect to review of the driver and vehicle services data and the use of that data.
Thank you, Ms. James. This being an author's amendment, we will go ahead and take a vote on the Senator Koran, if you want to move your amendment again.
Madam Chair, I'd like to move the A2 amendment to Senate File 1019.
Okay, members, please unmute and be on screen. All those in favor of Senator Koran's motion, please say aye and raise your hand.
Aye.
Aye.
Opposed? Motion prevails and is adopted. The A2 amendment is adopted to Senate File 1019. Senator Koran, to your bill as amended.
Thank you, Madam Chair. And today we have, this is a traditional process of a housekeeping bill for the Office of the Legislative Auditor, the eyes and ears of the legislative body. And so we're very happy to make sure that we continue to update, and clean our house with based on the recommendations from Mr. Nobles. And so with that, Madam Chair, I'd like to have him just go through and cover all the elements of this particular bill. So,
Okay, thank you,
Chair.
Senator Koran. And with that, Mr. Nobles, please introduce yourself for the audio record and so on. And then you can go ahead and start your testimony. Thank you, Mr. Nobles.
Thank you, Madam Chair. My name is Jim Nobles. I'm the Legislative Auditor. And first, I want to thank you, Madam Chair, and members of the committee for hearing this bill, and thank Senator Koran for sponsoring it. This bill was reviewed by the Legislative Audit Commission before it was introduced and approved by the commission, a bipartisan commission of the legislature. I will go through each section quickly. I do believe these are really technical and housekeeping provisions. For example, in section 1, we simply changed the name of some of the administrative support staff that we have at the office, and the name is in statute, and that's why we have to change it in statute. They are currently called confidential secretaries. We think that that name should be administrative support specialist, because confidential secretary makes it sound like they just work for an individual, but they in fact perform a wide range of office duties for the office. So that's just one very technical change. We also think we should remove a provision that mandated that the legislative auditor appoint a fiscal oversight officer for the work we do in auditing the metropolitan transit. That law that mandated us to do that work was repealed some years ago, but the provision on appointing a fiscal officer remained, and so it's simply unnecessary. So we asked for that to be removed. The next provision in section 1 is a little more substantive. It actually says that because the employees, with some exceptions, but most of the employees in the legislative auditor's office are in the classified civil service, that they should not be able to utilize a provision that applies to classified employees in the executive branch, and that is to run for public office while they remain employees in an agency. I was actually confronted with this situation not that long ago. I had an employee in my office who came and said, I'm going to run for a seat in the Minnesota Senate. And I said, that's not appropriate and consistent with your employment here as a nonpartisan employee of the Office of Legislative Auditor. It will raise serious concerns about your objectivity, and so I don't think you can do both, and you have to make a choice. And he pointed out that there is a statute that said, no, you either have to allow me to go on a leave of absence, you can't require me to go on a leave of absence to run for a political office. And so I was faced with a very difficult situation. He was going to run for a seat in the Minnesota Senate against an incumbent, and he could remain under the law on the payroll of the Office of Legislative Auditor. I think that's inappropriate, and therefore I ask you to support this provision that would not allow that to happen in the future. Section 2 simply recognizes something that has existed for many years, and that is that in addition to our financial audits and our evaluations, the Office of Legislative Auditor also conducts special reviews. We sometimes call those investigations. So that is simply making explicit in statute something that has been a part of our work schedule for many decades. Section 3 just removes old and unnecessary language that was a part of the original creation of the Office of Legislative Auditor in 1973. Section 4 replaces some pretty burdensome and unnecessary language and about our audits at the Department of Human Services, and replaces that with some language that Senator Koran has proposed in the past, which I think really would get us down and through the whole chain of expenditures that go on at the Department of Human Services, from the department to the counties down to nonprofits as well. So I think that's good language that we need to add. Section 5 clarifies that agencies have to cooperate with the Office of the Legislative Auditor and provide us with all documents and data that we need to do our work. Section 6 clarifies certain information that we can classify as not public, so that we can protect the identity of people who come to us as whistleblowers. They are often a confidential source and would not bring that information forth without being able to protect their identity. Section 7 are repealers, and I can simply go into those if need be, but they simply remove some language that we think is unnecessary for the Office of Legislative Auditor, mandate some audits that we think we already have jurisdiction to do and will do even without the mandate. So that's the bill, Madam Chair and members. Be happy to answer
Mr.
questions.
Nobles, for a good explanation of that. Appreciate it very much. And members, this bill is going to go to the Transportation Committee next. Senator Howe.
Thank you, Madam Chair. And Mr. Nobles, I noticed that it eliminates in Section 7 this salary study for the troopers, and I can see, you know, when that requirement came in, I know that to me it had a few too many, but it was what we had to agree with the other chamber to get it through, and I thought it was kind of excessive to have that number of studies, but I do think that a couple of those, we need to probably have 2 more of those studies. And I will say that the OLA did a fantastic job on that salary study. It was very, very informative. I tell you what, you did an excellent job of digging down and getting right down to the numbers. What I'm afraid of when you compare that to the salary study that MMB did, it is night and day the quality that was done. And I would hate to lose that, because I feel that if we don't continue to do those studies, it'll slip away. Now, with your comments, can you still do those salary studies without being mandated in law? Is that what I'm taking from this?
Madam Chair.
Mr. Nobles, yes.
Senator Howe, I believe that if you want us to continue to do those studies, you need to retain the law, possibly with some modification. And I would be most willing to work with you to accomplish that in the next committee. So it does fall a little bit. We have very broad jurisdiction, but it doesn't include everything. and what you asked us to do was a little bit outside of the existing jurisdiction. So we'll need to retain that law, and I'd be happy to work with you to accomplish that.
Thank you, Mr. Nobles. Appreciate that very much. And this will go to the Transportation Committee, which has specific jurisdiction in this area. So we'll leave it to Transportation. And Senator Howe and Senator Koran, you could go forward with Mr. Nobles. Senator Clausen.
Thank you, Madam Chair. Just a clarification on the section that prohibits an employee of the legislative auditor from being a candidate for elected public office. Does that include the local positions as well, serving on a school board, serving on a city council, those types of positions, or were you referring only to state positions?
Mr. Nobles.
Madam Chair, Senator Clausen, the language as it is written now would prohibit an employee of the Office of Legislative Auditor from running for any elected office, including local offices. And let me just tell you why we need that. First of all, there are local offices that have some partisan affiliations. even if they aren't strictly like running for the legislature. As you well know, often people are endorsed by organizations that carry a certain political affiliation, and certainly local officials. And we certainly see that in recent years at the local level, city councils, county commissions, school boards are often confronted with issues that have a very strong political orientation to them. And so if an OLA employee was serving on a school board, for example, it could have ramifications for your perception of that person as being nonpartisan, but it would certainly require the legislative auditor to not allow that OLA employee to do any work related to education. And that would be under generally accepted auditing standards, which have very, very strict requirements for independence. So if somebody was on a school board, they could not work on any of the work we do related to education. And for anybody serving on a county commission, we do a lot of work related to human services and deal a lot with counties. And so again, that would eliminate that person under our independence standards from working on any of those. In addition to the possibility that it would give some identity to that employee as a partisan rather than as a nonpartisan employee of the Office of Legislative Auditor.
Thank you, Mr. Nobles.
Thank you,
for
Mr.
that
Nobles. I
clarification.
appreciate that. Members, we have one more bill, and so this needs to move on to transportation. Senator Clausen, did you have another question or just a real brief comment, please?
Madam Chair, I just appreciated Mr. Nobles' clarification on my question. Thank you.
Thank you, Senator Clausen. He does a good job. I appreciate that. Senator Osmek, I'm coming to you right next, but I do want to just call on Ms. James briefly.
Madam Chair and members, if the intention of the author and the committee is to take out the repealer of the trooper salaries so that it can be amended in transportation, then we'd make an amendment to the repealer.
Ms. James, are you suggesting that that would be important to do today, or could that be done in transportation?
Madam Chair and members, I think it would make sense to just leave it in law now, take it out of the repealer, if the idea is to amend it in transportation.
I understand. Okay. Senator Koran, what is your
Madam Chair?
Mm-hmm.
Madam Chair, I would agree. I think we do agree. We're going to continue to work on it and make sure that we come up with a viable compromise on it. So with that, Ms. James, what would the oral amendment be to retract the repealer for 299D.03?
Ms. James.
Madam Chair and members, yes, the amendment would be page 5, line 5, delete and 299D.03, comma, subdivision 2A.
Senator Koran, is that your motion?
Madam Chair, I'd like to make that motion.
Okay, members, any further discussion on that motion? Seeing none, on the oral amendment as stated by Ms. James, please unmute and be on video. All those in favor, please say aye.
Aye.
Opposed? Motion prevails and the oral amendment is adopted. Senator Osmek.
Thank you, Madam Chair. To Senator Clausen, just a brief comment. If you look in, I believe statute, and I've been digging for it for the last 5 minutes. If you look in statutes, I believe it's in section 211, you'll see a prohibition on if you were, as an example, you're a city employee and you decide to run for city council in the city that you're a city employee, there is a prohibition. I bring this to your attention because actually that happened in 2010 before I became a senator. I was involved in creating that piece of language. So I think you'd probably find it in statute existing right now. If you work for a school board and you wanted to be on the school, you wanted to be elected to the school board, you're probably prohibited from the same language, but there is a language that talks about that already in law. Thank you.
Thank you, Senator Osmek. I appreciate that additional information. The value of a committee is very important. Well, with that, Senator Cran, I think we're ready to take action on your bill if you'd like to make that motion.
Thank you, Madam Chair. I'd like to move that Senate File 1019 be recommended to pass as amended and be as amended. I covered and be re-referred to the Transportation Committee.
Thank you, Senator Cran. Members, again, unmute, be on video, prepare for a vote. On Senate File 1019 as amended, all those in favor say aye and raise your hand.
Aye.
Aye.
All those opposed? Motion prevails. It is adopted. And Senator Cran, you're on your way to the Transportation Committee.
Thank you, Madam
With
Chair.
that,
and
members, we have a very brief amount of time, and we're going to defer Senate File 1422 till tomorrow, so that because we won't have enough time in the 4 minutes left on this committee hearing. So we will have that on the agenda tomorrow, which will make that agenda very full as well. And members, in order to, between this week and next week, in order to get through all the many bills that this committee will have to do, and we have been busy, we've gotten a lot done, but the nature of this committee has just has a lot of things and a lot of re-referrals also that come through the committee for a specific purpose. So we are going to be doing some timing and make sure that we can get through, because all of these folks have important issues to be discussed, but we're just going to try and make sure that we honor our fellow colleagues in getting these bills done. And members, with that, I will see you tomorrow, and the state government is adjourned. Thank you.